private civil right of action.
The chair recognizes Representative Slauson to explain the bill.
Thank you, Mr. Speaker and members. This is the Texas Heartbeat Act, and I move passage.
The chair recognizes Representative Howard to speak against the bill.
Thank you, Mr. Speaker and members. I'm not going to belabor yesterday's discussion. I just want to be clear on what we're voting on today. Senate Bill 8, which some have referred to as the Forced Pregnancy Act, will absolutely force most, if not all, women to carry their pregnancies to term because it does not rely on any actual science. And what's worse is that this bill will drive women back into the shadows in fear of harassment through lawsuits that anyone in this country can file. First and foremost, we're voting on a bill that enshrines personal beliefs over science. This ban on abortion at 6 weeks gestation is truly a ban on practically all abortions and just totally ignores the reality of women's bodies. Gestational timelines don't align with more commonly understood pregnancy timelines. ACOG, the gynecologists and obstetricians, they start counting gestation from the first day of a woman's last menstrual period. They also state that pregnancy is assumed to start 2 weeks after that day. The reality is that it usually takes missing a period before women start to even consider whether they're pregnant or not. That would be at about 2 weeks gestation at the earliest, which is when pregnancy is assumed to start. And in actuality, it will take at about 4 to 6 weeks gestation when women really start to notice that they've missed their period. This is why doctors are so opposed to the 6-week ban. It does not make any medical sense. The truly egregious provisions of this bill are its legal provisions. Cases of rape, incest, and sexual assault. The First Amendment by Representative Slauson yesterday only optically provides protections to victims of rape, incest, and sexual assault. The language clearly states that only rapists and other abusers who are prohibited by sections of the Penal Code are disallowed from bringing a civil suit against a victim. That means this only applies to rapists who have an actual conviction or an allegation against them. The reality is that 90% of women, 92% in Texas, do not report that they have been raped. Of those reports, only 3% of rapists are actually convicted. 1 in 6 women have experienced sexual assault, and nearly 75% of those cases are perpetrated by non-strangers, including intimate partners and relatives. This is partly why so many cases do not go reported. This bill will only affect those tiny percentages. This leaves the vast majority of victims unprotected from their abusers. And the amendment narrowly applies to the civil cause of action. If you were raped, if you are a victim of incest or sexual assault and you don't want to carry that baby to term, too bad. You will have to do that under this bill. To make matters worse, the civil cause of action is so broad that women will live in fear of legal harassment. Under this bill, you criminalize legal medical procedures and place huge liabilities on providers. And let's be clear, you're not just placing those liabilities on physicians who actually perform the abortion. For example, if a person became pregnant as a result of sexual assault and the rape counselor provided information to the victim about how to obtain an abortion, the rapist could sue the rape counselor. The rapist could sue the doctor who provided the abortion and anyone, including a family member of the victim who supported the victim in accessing an abortion. This is what the language that allows people all over the country to sue anyone who, 1, performs an abortion, 2, aids or abets in the abortion, or 3, intended to aid and abet in the abortion. These terms are so vague that they can apply to almost anything. Here's an example for all of the rural members who advocate for your rural hospitals, given that Texas has the most rural hospital closures in the country. In 2019, 0.001% of all Texas abortions were done in a hospital. This is because hospitals do not perform abortions that are not medical emergencies. Instead, your hospitals are going to refer out to other facilities that actually do perform abortions. So, under this bill, that would be interpreted as aiding or abetting an abortion. That's a huge liability. That is particularly bad given that there's a floor of $10,000 for fees that can be claimed against each and every defendant in a case. These frivolous lawsuits can ask for whatever amount they want, and it would be allowed under this law, and that is for each and every defendant. We know that rural hospitals are already set to lose millions of dollars in funding once DSRIP ends at the end of this fiscal year. Imagine being in fear of being held liable for who knows how much money just because you're doing your job and referring out a person who may want an abortion when you're not even the one performing the abortion. That is a chilling effect that you're placing on women and on facilities and on all types of providers. I will close by saying that I hope you listen to this, and while I understand how you may feel personally, I want you at least to know that this is what you're voting into state law. This bill empowers rapists and abusers. This bill empowers lawyers and trolls who want to abuse and clog up our courts. This bill completely ignores medical science and undermines physicians and providers. And most importantly, this bill, this Forced Pregnancy Act, disrespects women, puts us in harm's way, totally disregards our agency and autonomy, and drives us back into the shadows. As I said yesterday, this bill will not stop abortions.
Mr. Speaker,
Representative Ramos, for what purpose?
will the gentlelady yield?
Does the gentlelady yield?
Briefly.
The gentlelady yields.
Thank you, Representative Howard. To be clear, in this, you just referenced the amendment, but also according to the bill, an individual can also sue the insurance companies that maybe have provided some kind of assistance in the matter, whether it's the person gets sick or whatever. Trial lawyers will be able to increase litigation, so now they can sue insurance companies for this?
It is the most frivolous of frivolous lawsuit opportunities, yes.
Well, as an attorney, I think that's wonderful that we can increase the litigation and make attorneys, especially trial lawyers, a lot more money. And the final question, you spoke to the amendment, and there was that provision that a rapist cannot sue, or somebody, let's say, that was legally found that guilty of rape, they wouldn't be able to sue within this bill, correct?
They would not be able to sue if they're convicted, which is very rare. Yes.
Okay, but his best friend, one of my constituents pointed out, his best friend could sue, or the rapist's mother could sue, or the rapist's sister.
Anyone can sue.
That is just amazing. Thank you very much.
Thank you.
Mr. Speaker,
Representative Crockett, for what purpose?
will the gentlelady yield
Does the
for a few
gentlelady
questions?
yield for questions?
Briefly.
The gentlelady yields.
You know, I'm curious because we talked about litigation so much, and I thought we would have a more robust conversation because the representative that brought this bill is an actual litigator. What I didn't hear, and I may have missed it in the conversation yesterday, is most of us understand that when you go into court, you're going into court seeking damages, and you normally have to prove damages. And if you are a random, arbitrary person who normally would not have standing to sue for anything, what damages are you suffering, and what type of money should be paid when you had nothing to do with whatever happened with the doctor, this woman, this entire situation? Did we have a robust discussion about damages and how someone would prove up damages in the first place?
No, which is why I wanted to make this final statement today so people would understand that that is what we're putting into law here. And as you point out, you don't even have to have standing. Anybody can sue in this case, and they don't have to know the person, have anything to do with the person. It is really so open and vague as to be just right, as Representative Ramos was saying, for trial lawyers to have a heyday.
The only other question I have for you is, this exact same body put a lot of effort into passing HB 19
Yes.
to reduce litigation.
Yes.
For persons that say are hit and killed by trucks.
Correct.
We thought there's too many people suing.
Correct.
When people are being physically harmed in, say, trucking accidents. And so we've made a completely different set of rules for those that drive trucks. But now we're saying we want to encourage more litigation when there's not even damages for people. Is that
That's
how you
correct.
interpret what's going on with this bill?
That's correct.
Seems a little inconsistent, huh?
Yes.
Thank you so much.
Thank you. Thank you, Mr. Speaker.
The chair recognizes Representative Slauson to close.
Thank you, members. Thank you for the vote on this yesterday. I look forward to the passage of the Texas Heartbeat Act. And with that, I move passage.
Members, the question occurs on final passage of Senate Bill 8. It's a record vote. The clerk will ring the bell. Show Representative Slauson voting aye, Representative Hunter voting aye. Members, the chair will give you time to vote from your
I'm gonna
desk.
stand with you.
Show Representative Hall voting aye.
There you go.
Have all voted? Have all voted? There being 83 ayes and 64 nays, Senate Bill 8 is finally passed.